We're back here live talking about student-free expression and due process rights. So again, we're talking about free speech rights for students at public colleges and universities. Let me take you back to a time of student protests during the Vietnam War. You can see the types of issues that were occurring in society and colleges and universities. You can see what was happening in college and universities as well as K-12 education. There were protests during the Vietnam War. People weren't happy. So let me tell you about this case called Tinker v. Des Moines. Go ahead and read page 551 to 555, and it'll give you a sense of what was going on. So in a landmark case of Tinker v. Des Moines Independent Community School District, the U.S. Supreme Court offered one of the most memorable, meaningful statements in education law. It cited, "It can hardly be argued that either teachers or students shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." While Tinker arose in a K-12 educational context, it also has an application and inspiration to the higher education settings. As it is with most discussions of constitutional rights, the resolution of legal conflict usually leads to a balancing of rights and interests. On the one hand, there is the individual rights to exercise freedoms so foundational to our nation. On the other hand, there are institutional rights and responsibilities to establish and implement curriculum and policy and manage the institution's resources, personnel, and facilities. So let's hear what happened. In this case, Tinker v. Des Moines. So you read the facts. The event started in December of 1965. In Tinker, the U.S. Supreme Court struck down a school policy that prohibited students from wearing black armbands in silent political protest of the Vietnam War, primarily because the wearing of armbands did not materially or substantially disrupt the work of the school or infringe on the rights of others. The school administrators had been troubled by the protests been seen at local college campuses and elsewhere in the community, and they wanted to prevent it on their own campuses at this high school. In part one of this case, the court is making it clear that just because people are in a school building, that doesn't mean that you give up your rights of freedom of speech. So under part one, as you can see here on this screen, see the second sentence. Now, I've highlighted yellow. I don't have the sophisticated yellow and blue marker here because I'm using a PDF Adobe Acrobat type program. Now, go ahead and get your blue highlighter, and it says, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." The court wrestled with a critical issue, stating, "Our problem lies in the area where students in the exercise of First Amendment rights collide with the rules of school authorities." So you have a tension between First Amendment rights of the student and also that of the school's authority. Which is it? How do you resolve this issue? In part two of the case, the court conducted several steps to its analysis. This analysis is akin to what we would do as higher education administrators. Under part two, see the second sentence. Go ahead and highlight in yellow and blue, which again, yellow and blue make green, a silent, passive expression of opinion unaccompanied by any disorder or disturbance on the part of petitioners. Here we're referring to the expressions of these students. Also, let's go ahead and highlight this in yellow and blue, and that is, there is, quote, "no evidence whatever of petitioners' interference, actual or nascent, with the school's work or of collision with the rights of other students to be secure and to be let alone. Accordingly, this case does not concern speech or action that intrudes upon the work of the schools or the rights of other students." We don't have any disruption here. So if we had disruption, we'd see a very different situation about what the case outcome would be. Let me explain why these sentences are so important. First, we know that the speech or expression here is silent and passive. It just so happens it's a silent, passive expression of a political nature. We give those kinds of expressions a high level of freedom because it has political speech in there. Second, the silent, passive speech in this case was also unaccompanied by any disorder or disturbance. Hey, that's significant. That's significant because you could imagine that someone could wear clothing or some object that could stir up the campus community. For instance, a student in New York wore a Confederate flag to campus. we can see how that could stir up emotions and evoke a campus disturbance. In this case, though, the students wore an armband, and they were wearing an armband in protest of the Vietnam War. Pretty benign, don't you think? Now, critical to this discussion of Tinker, the court's continuing emphasis on the constitutional balance between individual rights and individual interests is there. The court explains that we, as higher education administrators, have a right to limit or regulate a student's speech or expression under certain circumstances. According to the Tinker decision, we learned the following, which, by the way, I'd like you to again take out your yellow and blue highlighters, which makes green, unless I otherwise noted it. So a public college may not discipline or impose rules that infringe on a student's speech based on undifferentiated fear or apprehension of disturbance, nor can it do it so based on mere desire to avoid the discomfort and unpleasantness. So if there's no indication of fear of disturbance, then a school can't really regulate someone's speech or stop them from speaking. We want to make sure we note that. However, a public college may discipline or impose rules on a student's speech when the student is engaged in the forbidden conduct that would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. So just think about that. If what we're saying here is if a student is going to have certain conduct that's going to be disruptive to someone's education, such as yelling a megaphone in class or creating a disturbance through some sounds of firecrackers outside of a classroom to grab attention, to protest an event, that would be problematic. As a general rule, a public college may not prohibit the wearing of all symbols of political or controversial significance without compelling governmental interest, and the rule must be narrowly tailored to meet that interest, or, if such a prohibition exists, it's to avoid material and substantial interference with schoolwork or discipline. So this is probably starting to sound familiar. We hear that the policies are kind of similar to last week's as well. Anytime the government restricts someone or makes something that's somewhat difficult for people to behave, in this case about letting them exercise their free speech rights, well, the government's going to say you have to have a compelling governmental interest. And whatever the policy is, it has to be narrowly tailored just to address that governmental interest and not more. But one exception is, well, if it materially or substantially interferes with the schoolwork or the discipline of students, that's when we'll say it's okay to discipline or regulate speech. Again, if it's disruptive to the school, to the environment, that would be okay to stop someone from speaking. So they don't necessarily have free speech rights in that instance. Again, we're looking for things that are disruptive. Now, I'd like to emphasize the rules of this case apply to both the classroom and other school events, which could be even outside the classroom. So it could be a rally, it could be an event with student activities, it could be at housing. Let's highlight in blue on page 554, halfway down the page. Okay, so we're about halfway down page 554. You see the quote, "The principle of these cases is not confined to the supervised and ordained discussion which takes place in the classroom." Like I just said, it doesn't always have to happen in the classroom. It could be outside the classroom. But it's related to the educational experience. So moving down the paragraph, also highlight in blue. Again, mine's going to show as yellow. Or as you scroll down, moving down the paragraph, also highlight in blue. When the student is in the cafeteria, or on the playing field, or on the campus during the authorized hours, opinions, even on controversial subjects like the conflict in Vietnam, or if she or he does so without materially and substantially interfering with appropriate discipline in the operation of the school, and without colliding with the rights of others. But conduct by the student in or out of class, which for any reason, whether it stems from time, place, or type of behavior, materially disrupts classwork or involves substantial disorder or invasion of the rights of others, is, of course, not immunized by the constitutional guarantee of freedom of speech. So as you can see, I sort of modified the quote to maintain gender inclusion, and the message is clear that we have to think about the message's location or space and its impact. A student may have free speech in other areas, But we also have to look at whether the speech presents materially and substantially interferes with the campus operations, such as studying, an athletic event, student activities, and etc. Now, these lessons and highlighted portions are important to quote if you're serving in some role that evaluates student conduct. You want to make sure that you know these words and they actually are part of your analysis. And later on in a few weeks, we're going to start to do student discipline activities. But we're going to learn how to discipline a student and write a letter to a student. You're going to see that some of the quotes from this case are very important to you. Okay, so what does Tinker and Des Moines stand for? It stands for these principles. One is that administrators, if they have reasonably forecast or an actual observation of substantial disruption. And what are some examples of substantial disruption? You'll see them here on the slide. Disrupts or creates disturbances in terms of classwork, learning, or educational access. Creates substantial disorder in school. And or the invasion of the rights of others without legitimate grounds. So it's something not merely to avoid discomfort or unpleasantness because it's an unpopular view, right? It's something pretty severe here, and it's disruptive to the campus. So that's one of the reasons why it's so disruptive to the campus that you can stop it. So as a college administrator, you want to have your toolkit and know where at times you can stop someone from speaking. And basically your goal here is to figure out ways that you can regulate what a student can or cannot say. Again, this applies to public college and universities. You don't want to always use this if you can avoid it. You want to work with students when you can, but sometimes you have to stop them. Let's take a scenario here. College rallied against Governor Mark Healey's campaign for U.S. Senator. Governor Healey opposes in-state tuition for undocumented college students, regardless of the number of years the students have resided in the state. The students participating in the rally wore t-shirts stating, "Education, not deportation." Later that day, students who support Governor Healey complained to the Dean of Students that the t-shirt was designed intending to make them feel marginalized, and they demanded the Dean of Students to require the protesting students to not display the t-shirts. That is, wear something over it, or wear the t-shirts inside out. Let's just assume for a second, you're the Dean of Students. What do? Now, this scenario is fictional. Keep in mind that the speech arises to political speech. It's a political in nature, right? Is it disruptive? Some of you may say it might be. You might debate that. Now think about this slide, and the next one I'm about to show you. Then read the report, Responding to Campus Protest, a Practitioner Resource. Now let's modify this scenario slightly. Suppose the undocumented students entry into college debate decided to express an opposing opinion to the education, not deportation end group. These students wore a t-shirt stating, "Got papers?" with a question mark. Students at the end group filed a complaint with the Dean of Students. They explained that they felt unwelcome and believed that the Got Papers group created a disruptive environment by wearing the t-shirt. Alright, you should have read Responding to Campus Protests. What do you think? You're going to have to answer this question in the discussion board. Symbolic speech can be really offensive sometimes, or really symbolic as they're intended to be. They send inherent messages when you see them. For instance, what about a Confederate flag? Or what about these hand gestures on that t-shirt that we see on this slide? Posted on Blackboard is an article labeled "Confederate Flag Raises Issues Ire at a New York College." The video and read that article. You should know the University of Rochester, which is named in this article, is a private university. Note that while Rochester has adopted policies similar to the constitutional standard, it does not have to, but once it does, it must follow its own rules. Think about the article and its impacts onto students. Does the institution have a right to regulate what a student posts on its dorm or residence hall room? It puts a Confederate flag up there. Is that acceptable? Is that okay? Can the school say, remove it? Think about the correspondences also that happened on Facebook. If there's something on the Facebook account that's posted that creates tension on campus, what can or cannot be done? Let's think about this. Again, another area for one of the teams to report on to the discussion board.
Is that safe?
Of course. I'm wearing protective gloves.
Oh, well, okay. Listen, welcome everybody. So I brought you all together today because I have some really great news.
In the 1960s, the symbolic speech that we were talking about were black armbands. Let's fast forward here. About just 8 years ago, college universities had a new challenge. And that was, they wanted concealed weapons on campus. So a new group formed, Students for Concealed Carry. Let's hear what they're up to.
It was meant to be a protest over the ban on concealed weapons on college campuses. Thousands of students from around the nation wore empty holsters to classes, except at Tarrant County College in Texas. A student there says the school banned even the wearing of empty holsters outside the campus free speech zone, which is a 12 by 12 foot concrete platform. So did this violate the students' constitutional rights to free speech? With me now, defense attorney Monica Lindstrom, as well as Anita Kay, who is a former prosecutor. Anita, the school within their rights?
Yes, Trace, they were. The empty holster that the students wanted to wear, they're supporting concealed weapons on school campuses, and they want to wear this empty holster. Now, when you see an empty holster, you look at that, you don't know if there's a gun in there or not. You start to think there's a gun nearby.
Yeah, except Monica, when I see 200 empty holsters, because it's part of a protest, and it's not just one guy walking around with a holster. I mean, this was publicized. They knew the students were going to do this. These empty holsters were very symbolic, and everybody was privy to the fact that there were kids carrying around empty holsters, right? Monica?
Yes, absolutely. And this case isn't about a gun or not. It is about the student's right to symbolic speech. Just like you said earlier, Trace, in 1969, the Supreme Court ruled in the black armband case that the students were allowed to participate in symbolic speech, and the school could not stop it from happening. That's exactly what we have in this case. He wants to protest a band. He's wearing an empty holster. There's no safety concerns about this at all. He should have been allowed to do it, and when the school told him he couldn't, they stepped over the line and they violated his rights, just like the Supreme Court found back in 1969.
But I got to tell you, Anita, I'm kind of finding it, I agree with you, it's kind of difficult to figure out the correlation between a holster worn on the outside of your clothes and a concealed weapons kind of thing, right?
Exactly. They want concealed weapons on campus. How does displaying an empty holster symbolically, is that a proponent for concealed weapons? It's an opposite. It doesn't even correlate. And seeing the holster, they wanted to carry these, go into the classroom with the empty holster. It wasn't just a protest out on grounds. They wanted to go into class with that. So people who aren't aware of it, other students see someone coming into the classroom with an empty holster, and you can't even tell if it's empty, could cause huge panic in the classrooms. And their concern is for student safety.
And this, by the way, was founded in the wake of Virginia Tech. I mean, students saying that they should be allowed to carry concealed weapons, and there were some 600 schools having these protests, Monica, and only one said no. So, I mean, you know, this school's got a whale of a people on the other side.
It has a problem because it violated symbolic speech. It has to do with guns in the sense that holsters carry guns. It's symbolic. That's the whole purpose of symbolic speech. You can't talk about concealed weapons in any other way. So the holster is symbolic. The school stepped over the line, Trace.
Anita, 10 seconds to you.
They didn't step over the line. The fact that the other schools didn't do it, this school did, and they took the appropriate action. Their concern is for the students and for their safety, and it could have caused a panic by showing that empty holster and students not knowing what that's all about. They did the right thing. Absolutely. Not at all.
Anita Kay and Monica Lindstrom, ladies, thank you both.
Thank you.
What do you think of the empty holster case? And there's some other examples too, again, for the discussion board. So there's a group out there, one of the groups that's in this class. You're going to have to respond to this question on the discussion board about the empty holster case. Is having an empty holster on campus, is that symbolic speech? Is it protected by the First Amendment? What do you think? Here are some additional links if you wish to watch some videos about the whole empty holster case. And then also, I've added a documentary on the Virginia Tech massacre. Just something to think about the whole idea of having guns on campus and the empty holster protest. Are they the same? Are they different? What's the issue? We've talked a lot about different types of speech and things that students say, perhaps, but there's some types of speech or expressions that college students or others in the college community may express that we kind of consider have low protection. We consider them with low protections because, for the most part, they're areas that we don't protect as part of free speech. We don't consider them free speech, or they cross the line of what would be acceptable free speech. Let's take, for instance, obscenity. So there's lots of things that are obscene, but how do we determine obscenity? Well, our definition basically is it's an expression that the average community member considers as appealing to prurient interest, patently offensive, and lacks social, political, and scientific value. As you can guess, if it's the average community member, it depends on what's your community. The second thing is, it's the average community member at the time. And as we know, what is obscene as of 1960s is different from what is obscene in the 1980s versus the 2000s. Another area is fighting words. And we tend not to support fighting words, and that is speech used in a confrontational manner or as a form of threat to provoke immediate violence. It's not that often, actually, that we get these cases in higher education that deal with fighting words, but they may exist, particularly with online speech nowadays, that they may arise so you can consider. Another area is incitement. It's speech that provokes the listener to engage in immediate violence. For instance, there may be something that could be provoking someone to actually act in a way that may harm another person based on something, the message that's conveyed. Again, not very often. We haven't even seen it in higher education, but it's something to think about. The court cases have told us these things do not support higher freedom of expression. There is one area that's sort of come up in higher education, and that's what we call true threats. And that is, a speaker communicates a serious expression of intent to commit an act of unlawful violence to a particular individual or group of individuals. We've seen those situations in higher education quite often, actually. Sadly, it's come through areas such as threats of bombings, threats of shootings, and threats of bodily harm onto another individual. They come in written form, through emails, texts, and phone calls. Another area that's not protected by the First Amendment is defamation, basically the false expressions about another. Another area where speech often occurs on college campuses that we don't protect. We talked about disruption, substantial disruption. That's expressive speech that actually are reasonably forecasted to lead to material disruption or substantial disorder on campus. We actually can regulate that. Harassment we'll cover more of in a few weeks, but harassment applies to protected classes experiencing unwelcome and sufficiently severe or pervasive to create an intimidating, hostile, or offensive environment. Sexual harassment is what we're accustomed to, and that's actually where it typically occurs. Harassment has occurred for persons with disability and, on occasions, for persons who are ethnic minorities. Hate speech is speech that identifies an identifiable group in a protected class, typically ethnic minorities, that links to threatening or disruptive behavior or acts of discrimination. I have to say, as sad as it may be, hate speech actually does not get us very far. By claiming something as hate speech by itself, in many cases, has not helped us in disciplining college students at public institutions. We'll see some examples coming up in the next few weeks. But as I'm trying to make clear, disruption, disruptive speech, that's what we learned from these cases. That's what the issue is right now, and those are the areas. It's one of the easier areas to regulate student speech if you're concerned about what disruption is caused on campus. Here's an example of student protest at a sit-in, and that someone might consider disruptive. another quick video to see about is this overreaction by the campus police or not. As one news commentator mentioned on Fox News, the spraying of pepper spray, it's just pepper. So it's a vegetable, so it's no big deal. Student protests have also taken on another form. There's these dying protests where everybody lies on the ground and plays dead. How do you think this protest fares with respect to disruption on the campus?
Kid, quit snapping those photos.
Oh, sorry, officer.
In fact, hand over that camera right now.
But my summer camp photos are on there. Will I ever get it back?
Watch out, kid. If you keep talking back, I'll have to arrest you.
Oh, no, please, officer. I didn't know I was doing anything wrong.
I think I hear somebody's liberty in danger.
Whoa, Benjamin Franklin?
That's right. And I'm here to tell you you didn't do anything wrong. In fact, that officer was the one who messed up. Just because he had a badge doesn't give him any right to be mean. And he sure doesn't know much constitutionally. You see, it's everybody's right to point and click. If you're in a public space, you're a dude or a chick. Taking photos are your right in a free society. Let me kick a rhyme. You can't turn the lights off now. The world is much too small. When anybody's rights get wronged, it's everybody's wake-up call. Corruption thrives on secrecy. Transparency is good for you and me. And we really want to see the truth set free for all.
Why did he have to take away my camera?
Recently, some police are ordering people to stop filming in public places. They're infringing on your First Amendment right. And I should know. I was there when crazy old Jim Madison wrote the thing. Cuddly son of a gun.
So you think I can get my camera back?
You bet your pantaloons. Without a warrant or reasonable suspicion of a crime, that cop can't legally take your camera. So let's go get it back. Excuse me, officer, this nice little lady wants her camera back.
Yeah, that's me.
Unless you reasonably suspect it contains some criminal facts.
Oh no, I forgot to brush my teeth.
It's the little girl's right and everyone's job to monitor the government's enforcement of law. Are you worried there's a photo of you that might get you sacked? You see, kid, even cops make mistakes. It's our job to keep an eye on them. And it's easy with your modern technology, your crazy iPhones. Why, in my day, I had to draw charcoal pictures of crimes and borrow Tom Jefferson's polygraph to make copies.
Wow. I didn't know digital photos and videos are such a great way to encourage transparency.
That's right. And it's important to share what we see with the world.
Now I can't get away with pepper spraying minorities. I'm gonna miss that. Well, I knew that it was wrong, but I didn't think I'd ever be seen. Now the whole world knows me. I'm YouTube famous, but only for being a big pain in the anus. All because a kid learned about civil liberties.
Whoa, knowing my rights makes me like a liberty ninja.
They can't turn the lights off now. The world is much too small. Cause everybody's plugging in. They're passing on the wake-up call. Corruption thrives on secrecy. Transparency's up to you and me. And we really want to see the truth set free for all. Help us out, Founding Fathers. They can't turn the lights off now. The world is much too small. Cause everybody's plugging in. They're passing on the wake-up call. Corruption thrives on secrecy. Transparency is up to you and me. And we really want to see the truth set free for all. Well, see you later. We gotta get back to our wormhole.
Thanks for teaching me about my rights.
And that's it for video 2 on First Amendment, free speech rights, and due process. Stay tuned.